Please be seated. We will swap.
Thank you very much. Court officer, please call the case.
Thank you, Mr. President. Situation in the Republic of Kenya in the case of the prosecutor versus William Samoei Ruto and Joshua Arap Sang, ICC 01090111.
Thank you. Please, appearances.
Good morning, Mr. President, Your Honors, Mr. Attorney, counsel for the victims, counsel for the defense. I'm appearing on behalf of the prosecutor, James Stewart, deputy prosecutor. I'm with Anton Steinberg, senior trial lawyer, and counsel Lorenzo Pugliatti, Rod Raston, and Thomas Bifwole, and our case manager, Yasmina Zuljanovic.
Thank you very much.
May it please, Mr. President, Your Honors, Wilfred Nderitu, appearing for the victims, assisted by Mr. Ochlon Narantsetseg from the OPCV, and also we have a new person, Mr. James Mawira, my case manager. Thank you.
Thank you. Mr. Khan.
Good morning, Mr. President, Your Honors. Mr. Ruto is represented by Ms. Shamla Alagendra of counsel, Ms. Lee Laurie and Mr. Anand Shah, our legal assistants, Ms. Shalini J. Raj and Ms. Grace Sullivan, trial support. Your Honors, my name is Kareem Khan.
Thank you very much. Mr. Keegan Katwa, you are the back.
Morning, Mr. President, and everybody else. For Mr. Sang is Katwa Keegan, Caroline Busman, Logan Hambrick, and Honor Lanham. Thank you, Mr. President, and Your Honors.
Thank you very much.
Mr. President, my name is Gedhu Muigai, Senior Counsel of the Kenya Bar and Attorney General of the Republic of Kenya. I appear here amicus curiae at your invitation, Mr. President, and I want to thank you. I appear with my assistants, Mr. Dan Ochieng, Ms. Caroline Wamaida, and Mr. Tom Odede.
Thank you, Mr. Mugai. We're happy to have you with us. It would have been my preference for you to sit on neutral grounds, since you're not a party in the case. But I was told shortly before we came in that your preference is to sit where you are. And I thought that amongst legal friends, we shouldn't quibble about where we sit. Welcome. We are here today to discuss the matter of the prosecution request for summons, compulsory summons to certain witnesses that once were on the list but no longer, or they're having difficulties with. We thought it is a matter that required some discussion in light of the novelty of the issue, or the issues rather involved, and it is for that reason that we thought we should invite the government of Kenya, represented by the Attorney General. And I wish to note that it's extremely rare to find a lawyer inside or outside the courtroom with the credentials of Mr. Mugai. I say that advisedly, and I'll tell you why in a minute. I know that in addition to being the chief law officer of state party, he is also a senior counsel. He's a doctor of laws. He was the UN Special Rapporteur for, I think, racism, racial discrimination, contemporary forms of them, xenophobia, and related intolerances. So we expect that, we must presume, of course, that he's here to help us a lot in trying to figure out the laws of Kenya on this thing and related aspects of international law. We're not bound by his views, of course, but we're happy to have you. Now, prosecutor, could you please, I will have you go first But as usual, we will operate under the time limits regime. We will take submissions in rounds and see how we go with them. How much time do you think you would have to make your oral submissions on hopefully the highlights of the high points of your submissions, in addition to any updates that you feel may need to come in that may not have been captured adequately in your written submissions? How much time do you think you will need?
Mr. President, I'll take whatever time you accord me, but if you ask for an estimate, I would say 45 minutes at the outside.
Why don't we begin with 15 minutes for the high points and any updates? We'll begin with that, and then we'll take 15 minutes all around. Please.
Mr. President, Your Honors, the fundamental question for decision in the matter before you is whether a trial chamber has the means, with the assistance of a state party, to obtain the evidence it needs to determine the truth. And specifically, the question is whether the power of the trial chamber to require the attendance and testimony of witnesses residing in the territory of the state party has any real substance. In our submission, the trial chamber does indeed have the means under the Rome Statute necessary to secure the evidence it requires. It was never intended that a trial chamber of the International Criminal Court dealing with the most serious crimes of concern to humanity would be denied this ability. It's an ability any criminal court in any jurisdiction must have. Now, my plan this morning was to state succinctly what relief the prosecution is seeking and why. Secondly, to explain the legal basis for granting the relief, which is the heart of the submission I'd like to make. And finally, to sum up our position in conclusion. Of course, we rely on our written filings. I'm just going to touch the highlights as you've indicated, Mr. President. The relief we seek is a request from the trial chamber to the government of Kenya for assistance to summon witnesses before the trial chamber to testify in Kenya, and if necessary, to compel their appearance. Now, the witnesses would testify not at the seat of the court in The Hague, but either via video link from Kenya or before the trial chamber sitting in Kenya. The need for this assistance arises because the witnesses will no longer attend voluntarily in The Hague to testify. They have recanted the statements they gave to the prosecution and have withdrawn their cooperation. The evidence of these witnesses is necessary, however, to the ability of the trial chamber to determine the truth. And thus the objective of our request is to secure relevant evidence bearing on central issues in the trial by means of the compelled attendance of unwilling witnesses at a location in Kenya.
Mr. Stewart, just on the point of the relief, I've noted too, you've indicated video link.
Yes.
While the witnesses in
Yes.
Kenya, or the court sitting in Kenya.
Yes.
What about the third possibility, that is the possibility of a rogatory commission, if it, as it were? Is that something you will not at all contemplate in your relief?
If the rogatory commission, if I understand your question correctly, Mr. President, involved a member of the chamber and the participation of the parties and participants, it's not something that we have articulated in our application, but it's certainly something worth considering. I should say right away that we're not seeking the taking of evidence by the High Court of Kenya, which is a mechanism available under the statute and under the International Crimes Act 2008 of Kenya.
That is what I'm thinking.
We're not seeking that, and we're not seeking it for several reasons. The principal one being that there is still in force in Kenya today an injunction preventing a High Court judge from engaging in such an activity. That's referred to in our written materials. And if need be, we can provide you with the decision of the judge. I believe that's been in place for about 3 years. But also, we would suggest that in such an activity, witnesses, it may be a challenge for a Kenyan judge to take such evidence unless there was permitted full participation by the prosecution, the defense, and counsel for the victims. So there are difficulties in the way of that potential route of remedy. So that's why we focused on the particular relief that we are seeking.
But what if right of audience were granted to a member of the counsel from the office of the prosecutor to attend? We know that victims' counsel is already a member of the Kenyan bar, so he wouldn't have difficulty appearing before the Kenyan judge. But assuming all that's left of it is for right of audience for a member of the OTP to attend, would that satisfy things, assuming that Mr. Mugai, when he speaks, is able to tell us that the injunction that you talked about is not an issue, or that it is an issue that can easily be overcome?
Well, I'll be cautious in my response and say that we would certainly consider that. The advantage that this trial chamber has over a Kenyan judge, and of course I recognize that this is a Kenyan court for all intents and purposes, but the advantage that this trial chamber has is its familiarity with the case. It will be much easier in a live, if you will, by video link or in actual physical presence, consideration of the evidence for you as judges to assess credibility issues rather than having something packaged up and sent to you by the mechanism that you have mentioned, which I suppose would be Rule 93.1b. Rule 93.1b may have an application, but if you're sitting as a chamber in Kenya, I'll come to that if I get a chance later.
Please proceed.
Thank you. Mr. President, I don't intend to go through the matters that are covered in the early part of our application, namely the general nature of the evidence of the witnesses in question, its relevance, the basis for believing that they won't attend voluntarily, and the grounds for believing that they are currently residing in Kenya. I rely on our written submissions, and I won't take up time here, and there are other reasons why I probably shouldn't speak about them in a public setting. I might add, however, that the matter is one of urgency. Only a week ago, yet another witness on the prosecution witness list recanted in a very public fashion and did not turn up at the appointed time to come here to The Hague. This is a witness who was expected to testify very shortly.
On that, we've read your written matter, and you've now also indicated that another witness has recanted in a public fashion. That is a theme that appears to recur in your written submissions, witnesses recanting in public fashion. What does that do for continued masking of the witness's identity, as it were? Have you given a thought to that?
Well, it may, but I certainly wouldn't invite the chamber to remove any of the protections at this stage for any of them. I'll come now, if I may, to the basis for granting the relief that we're seeking. The basis for the relief we're seeking rests primarily on two provisions of the Rome Statute, namely Articles 64.6b and 93.1l. Under these provisions, we submit the trial chamber may require the attendance and testimony of witnesses, and to this end may request the assistance from a state party to compel the attendance of the witnesses at a time and place within the requested state. and the state party must comply with this request for assistance unless it is prohibited from doing so by a national law. This relief is embedded within a broader range of provisions in the Rome Statute, which I need not detail, Mr. President, unless you ask me to. These provisions empower the court to require the full cooperation of states parties in the achievement of its mandate. There are certain issues which I feel I should address right away in relation to the provisions that I've mentioned. Article 64(6)b, as you know, empowers the trial chamber in performing its functions during the course of a trial, as necessary, to require the attendance and testimony of witnesses by obtaining, if necessary, the assistance of states as provided in the statute. The equivalent language in the French text of Article 64(6)b reads in its relevant parts as follows. Dans l'exercice de ses fonctions,
In discharging its functions, its duties, the trial chamber may, if necessary, order or require the appearance of witnesses and their hearing, and require the assistance of the state's parties under the statute.
To you is to demonstrate that there is no significance to be attached to the use of the verb require rather than order in the English text of the provision. They come to the same thing. It's a distinction without a difference. This is obvious when the French text employs the verb ordonner, to order. Both texts are equally authoritative by virtue of Article 128 of the statute. I would note, too, that Article 67(1)(e) of the statute protects the right of the accused to obtain the attendance and examination of witnesses on his or her behalf under the same conditions as witnesses against him or her. Mr. President, one way for the trial chamber to require the attendance and testimony of a witness is through the issuance of a summons to the witness to appear at a time and place indicated in the summons to testify. Article 93, sub 1, obliges states parties in accordance with Part 9 and under procedures of national law to comply with requests by the court to provide certain specified assistance. And that phrase, under procedures of national law, is designed in our submission to facilitate compliance, not obstruct or impede it. Article 93, 1D specifies cooperation respecting the service of documents, including judicial documents. Now, Kenya, as you know, has domesticated the Rome Statute through passage of the International Crimes Act 2008, or ICA. The ICA mirrors the relevant provisions of the Rome Statute and provides for implementation of Kenya's obligations as a state party. The ICA thus makes provision for the response to requests for assistance from the court. And these provisions include assistance in relation to the service of documents, including judicial documents, with document in the Kenyan legislation being defined to include, quote, a summons requiring a person to appear as a witness, unquote. Now, we have distributed a rather bulky book of references, and I'm not going to take you to the tabs in the time I've got, but I'll just note that the ICA is at tab 1, and the provisions I'm referring to, which are entirely uncontroversial, are to be found in section 20 and section 86. This relates to the service of documents, including a summons requiring a person to appear as a witness. That definition is found in section 86, sub 3, paragraph A. The question then is whether it is entirely up to the witness to appear in compliance with the summons or not. Is attendance as a witness merely voluntary in all circumstances under the Rome Statute? If so, this would mean that the trial chamber would be denied one of the most basic means any criminal court must have to acquire the evidence it needs to ensure a fair trial and determine the truth. Did the framers of the statute really intend the court to be denied the most basic powers enjoyed by any domestic criminal court? Mr. President, the answer to the question whether witness attendance is voluntary involves the interplay between the powers conferred upon the trial chamber by the Rome Statute and the purposes to be achieved by the exercise of those powers on the one hand, and the obligations assumed by states parties and the operation of national law on the other hand. I would like to examine briefly the legislative provisions relating to state party obligations. Already noted Article 93(1). Thus, with respect to the attendance of witnesses, states parties are obliged to facilitate the voluntary appearance of persons as witnesses or experts before the court, pursuant to Article 93(1)(e). That's right there in the statute. And Kenya, of course, has made provision for this in its ICA. However, it's our submission that it is clear from its legislative history that Article 93(1)(a) was drafted in the way it was in order to address the concern of certain states not to be compelled to send their witnesses outside the country to appear as witnesses or experts. And without going into detail, just to save time, as a matter of horizontal state-to-state mutual legal assistance in criminal matters, states are not generally required to compel witnesses without their consent to attend before a court in a jurisdiction outside the territory of the requested state. An example of that is Kenya's own Mutual Legal Assistance Act 2011, which I would refer to you to in Section 15. That's at tab 4. States, of course, can provide otherwise, and Kenya appears to have done so in its Witness Summonses Reciprocal Enforcement Act, which is at tab 5. There is an ability to for enforcement of summonses where the requesting state has agreed to do the same thing for Kenya. All of this relates to the attendance of a witness outside of the territory of the requested state, and we are not seeking this form of cooperation. We're not asking for the witnesses to be sent out of Kenya to The Hague. As well, the temporary transfer of persons in custody is provided for in Articles 93(1)(f) and 93(7) of the Rome Statute, and it requires the consent of the prisoner and the agreement of the requested state. But my submission is that this requirement relates to concerns about prisoners' welfare and treatment. And again, it comes from traditional horizontal state-to-state relations. And Kenya, of course, has made provision for this in its ICA. And we're not seeking this form of cooperation. If I may, Mr. President, what I'd like to do in what time you give me now is simply to summarize what I understand to be the contrary argument in order to explain to you in a few words why we say it doesn't work.
Before you do that, Mr. Stewart, you say that Article 93(1)(e) was inspired by the reticence of some states to compel their citizens to appear in a court outside their territory. First, I ask, do we have evidence of that reticence in the trouble?
Yes.
That's one question.
No, sorry.
And the second question would be, in light of the notion of complementarity, is this court in the same position as the court of another state, for whom the state might worry about sending their citizens to go and appear before, noting that the court is a complementary institution to which the enabling instrument of which the states parties are parties to.
I'm sorry, Mr. President. I wanted to say the evidence for the submission I made about the reticence of states is cited in our original submission. I'm going to ask Mr. Raston just to refer me to that, and I'll give you the reference. And with respect to the second question, my submission would be, of course, that this court is not in the same position as another state in a horizontal relationship. As one of the comments on the Rome Statute, the one I think written by Kress and Prost suggests, it's a blend of the horizontal and the vertical, if you will, in terms of complementarity. My position is that with respect to the powers that the Chamber has, the exercise of those powers is completed, if you will. It's executed through the assistance of the states parties. That's where the concept of complementarity, but also a level of verticality enters into it. That's my basic thesis. With respect to your first question, I think you'll find the answers on footnotes in our original submission to you, footnotes 48, 49, and 50. That's paragraph 75, 76, I believe. That's the area. I won't read it to you now, but it's there. What I was going to suggest is that the argument that's put against the position we're advancing, Mr. President, is that what is said in Article 93, 1E and F really exhausts the powers, or should I say the obligations of states to comply with requests from a trial chamber in relation to the requirement for the attendance and testimony of witnesses. And so what's expressly said in Article 93 exhausts the power according to the argument, and that means exhausts the power under Article 64, 6B. The ability to require witnesses to attend thus depends upon their willingness to attend. State parties are only obligated to facilitate the voluntary attendance of witnesses. There's no power of compulsion under the Rome Statute, and therefore no obligation by states parties to compel. There is thus an unfortunate, even lamentable, disconnect between the power conferred upon a trial chamber by Article 64, 6B on the one hand, and the obligations imposed on states parties by Article 93, 1 on the other hand.
Mr. Stewart, let me stop you. The reason I say that you've now gone into anticipating, which, of course, is an intelligent anticipation of the case against your application. I think it might be better if you waited and dealt with that in reply. That will give you also more time to deal with it instead of being squeezed in time to do that. But before that, my one question for you on the significance of 93.7,
Right.
Article 93.7. In paragraph 23, I believe, of your reply, your written reply, you in looking at it, you try to distinguish the jural value of Rule 193 and contrast it with the regime indicated by Article 93.7. And you say this, I quote, the import of Rule 193 is significant, as it shatters the argument that as a matter of principle, the Rome Statute prohibits the compelled appearance of witnesses. There is no reason why this rule should be held to conflict with the statute under Article 51.5, except if the highly specific and narrow regime created by Article 93.7 is artificially extended to apply to all potential ICC witnesses. As the prosecution has submitted, Article 93(7) creates the exception, not the rule. It is that I'm concerned with now. The exception, not the rule. Exception to what I think you mean, exception from compelled appearance. But you tell
Yes.
me also.
Yes.
But why the exception?
Well,
Something that it would be helpful to hear fuller argument upon. Why that exception?
well, you've understood perfectly, Mr. President. Our position is that the rule is compelled testimony. Of course, it can't be compelled testimony before here. You can't, I should say. The trial chamber can't compel a state to send someone who doesn't want to come. But we say that the rule is that the state can be compelled to compel a witness to come before you in the requested state. But with respect to the matter of prisoners, it's my understanding that this was a long-standing rule, if you will, to protect prisoners in terms of, were they close to their families, what were their conditions of detention, what programs were they involved with. In other words, issues relating to prisoner welfare is my understanding of it. So this was an exception carved out where you needed not only the agreement of the state but the consent of the person in custody. And Rule 193, we suggest, isn't inconsistent with that because you're dealing not with a prisoner in a requested state. You're dealing, in effect, with your prisoner, someone serving sentence under a judgment of the trial chamber or of the court. I think that's the best I can do.
The argument, of course, against you is under Article 93(7), we're dealing with somebody who's already in a compelled loss of freedom.
Yes.
In custody.
Right.
And I imagine the argument would be, well, if you cannot compel that person who's already in a state of compelled loss of freedom to appear, how can you compel somebody who's enjoyed full right of freedom in society? How can you compel them to appear? That would be the argument, isn't it?
I'm sure I could answer your question, but I think you'll get, I submit you'll probably get a better and clearer and more succinct response if I can deflect the question to my colleague, Mr. Raston.
Mr. Raston, your side is already out of time, but you can answer that in 2 minutes.
Thank you, Your Honor. Mr. President. Very briefly, as the Deputy Prosecutor mentioned, the provision 937 is basically reflecting and borrowing from traditional mutual legal assistance regimes.
I know, let's not talk about the genesis of it. The point is, if you cannot compel somebody who's already lost their freedom and is in custody somewhere, if you cannot compel them to appear before the court, how can you compel a citizen who's enjoying full right of freedom in society to appear?
Sure. I'll try to respond in 2 minutes, but I may require just a little bit of background. So, as Your Honor is aware, in traditional mutual legal assistance regime, the principle is one of reciprocity, of respect for state sovereignty, and to limit the compulsory measures that may be taken in a foreign jurisdiction against your nationals without your consent, or in specific cases, the consent of the person who's required to appear. So if one looks at either the transfer of prisoners for the purpose of testimony abroad, or indeed the service of a summons on a witness in your territory to go abroad, the regime is always by consent. And this is the same way actually reflected in Kenya's mutual legal assistance regime. We noted in our tabs and our submissions reference to the 2000 EU Convention as being very relevant in this regard because the EU Convention scheme of 1959 replicates exactly this scheme. It has a provision to do with prisoner transfer that requires their consent, It has a provision relating to the appearance of witnesses abroad, which again has their consent in the 1959 scheme. And then in the year 2000, the convention that is adopted supplements that previous convention and creates additional types of assistance which states may agree to. And one of these additional types is called testimony by video link in the territory of the requested state. Now, our argument is that this is a completely different type of assistance to the other forms that are foreseen. And this is evidenced not only by state practice, it's evidenced by the EU Convention itself. Clearly, the provision on video conferencing in the 2000 Convention neither replaces the earlier provision dealing with witness appearance abroad, nor does it conflict with it. It's described as supplementing it, and it is an additional type. So the two things do not contradict each other in state practice, and we submit neither should they contradict each other here in the context of the Rome Statute.
Are you telling us that in the EU practice or conventions you're thinking about, although you may have you do have the presence of a norm that's reflected in Article 93.7, you're saying that despite that, the EU practice and convention also recognize this compelled appearance of witnesses not in custody before other courts?
Yes, Your Honor. We've listed it in tab 6 of the binder. It's a specific provision, I believe it was Article 10 of that convention, that deals with the specific scenario of a request for witness testimony to be taken in the territory of the state, and the regime is one of video conferencing. It's very similar to what we're describing. And it's very relevant and of assistance because it describes a number of the issues, including objections that can be raised by the state, the costs involved, the practical aspects, whose jurisdiction the witness falls under whose direction the witness testimony is to be given. So we're not suggesting that Kenya obviously is bound by this convention, but what we are suggesting is that the notion of testimony via video link and the ability to compel somebody is a different assistance type to requesting a witness to go abroad. And in the EU context, that is made perfectly clear.
Thank you very much. I will invite Mr. Khan. I noticed that the prosecution had quite overrun that time, but because I was asking them questions, so you can go.
I'm grateful, Mr. President, and I will follow the same guidance as was given, same instruction as was given to my learned friend, that I'll try to encompass or touch a few points within 15 minutes or so. And then if there's later more detail required to flesh out, I'll do that with the court's leave. Your Honour, sometimes one cannot see the wood for the trees. It's always helpful, in my respectful submission, to stand back when there's a problem and look at context. And in that regard, and it's somewhat ironic to think, why are we here today on Valentine's Day? It's all about a failed marriage between the prosecution and witnesses who were seduced by inducements and promises of a better life. And, Your Honour, the relationship has clearly irretrievably broken down. And the prosecution, in their filing, is clearly, we say, alleging or inferring foul play. Because that's the only reason why in the filing repeatedly the prosecution underlined the fact that allegedly after disclosure to the defence, witnesses withdrew. Your Honour, before we get to the substance, with your leave, I suggest that narrative does not withstand scrutiny, because it is very understandable that if witnesses at the outset have been induced by benefits to give an account that they think is wanted.
Mr. Khan, let me cut in here. As I understand your argument, correct me if I'm wrong, reading your paper, you're not opposed to the idea of compelled appearance per se. Your concern is that it does not translate into requesting a state to facilitate compelled appearance as opposed to voluntary one. Isn't that what your argument is?
Your Honour, the argument that I've stated in court previously and I've said in Kenya recently is that all witnesses should be encouraged to speak the truth. All witnesses should, if they wish to withdraw, they should have the courage and, of course, the full gamut of protection from all sides from the court is there to come and explain why they're recanting or withdrawing. But, Your Honour, they cannot be compelled to do so under the statutory scheme. They cannot be compelled to do so under
Sorry,
the statutory
compelled to do what?
They cannot be compelled under pain of a imprisonment or a fine to come and appear at any locations. They cannot be deprived of their liberty in circumstances where there is no law in place that allows their liberty to be restrained.
So then, I just wanted to understand your argument. So I think we're getting there. I had understood, maybe it was a misunderstanding on my part, that your argument in the written material was a little more subtle, in the sense that I remember you in some places you do speak about that the statute might have envisaged an obligation on the witness to appear, but that the witness, that the court may not request the state party to compel the witness. But are you now saying, in fact, that your position is that a witness is not compellable to appear before an ICC trial chamber? Is that what you're saying? So we know what you're saying.
Your Honour, the court can issue any orders the court think is necessary and that are consistent with the statute. And I can envisage situations where the court can, of course, request Kenya to serve a summons requiring witness X to appear. But, Your Honour, that's the end of it. There cannot be a threat that if witness X does not accede to the requirement or the order of the court, that the witness can be incarcerated, deprived of their liberty, bundled into a van and taken to a location.
But the statute, neither the statute nor the rules say that, do they?
Your Honour, the statute makes it clear, we say, that, and that's the reason, one of the areas of wisdom by the drafting of the statute, that appearance must be voluntary. The appearance must be voluntary. I mean, that's the nub of it, because we get into a Pandora's box. I'll deal later with issues of modalities and where it could all lead. It'll be a complete mess. And, Your Honours, before I move on, sometimes, not always, when a legal argument is so complex that one ties oneself up in knots, it's not the right argument. And we say that the statutory regime, contrary to what my learned friend states, does not present a lamentable disconnect as presented, but in fact a comprehensive regime that combines both horizontal and vertical obligations. That the prosecutor has not wished to avail herself of the provisions under Article 91 1b is a matter for the prosecutor. The injunction, of course, applies to Justice Rawal. The prosecutor haven't even attempted to use that article. They could have used it before trial started. They knew in relation to at least some of these witnesses before trial started that they had recanted, that they said that they had told a pack of lies, and that they were not willing to assist the prosecution. It would have behoved, we say, the prosecution not to have marched blithely on, but if they wished to, they could have made the proper application in Kenya and saw what happened. And, Your Honour, one sees again a complete disconnect, a lack of consistency in what should be a unified office, because in the Kenyatta case, in the sister case, in the companion case, what did the prosecution do? Quite rightly, faced with a witness who conceded, yet another witness, who conceded that he had told a pack of lies, and a witness who had decided that he did not want anything to do with the office of the prosecutor conceded there were only pebbles left and there was not any realistic prospect of conviction. And what the prosecutor did in that case is refer to the provisions of Article 87(7), non-compliance. Yet the same office, in this case, takes a completely different tack.
Yeah, but we cannot presume why the prosecutor would have treated different matters differently. What I wanted to find out from you is whether, in your view, I mean, you spoke about vertical and horizontal obligations, would in there, in somewhere in that axis, come in an obligation upon a witness to appear before the court if the court were minded to make such an order upon a witness?
Your Honour, the only circumstances where a witness can be compelled is in circumstances where the witness is already before the court. But the actual task of deciding to give evidence, the actual task of travelling to the court and getting into that seat and taking the oath must be voluntary, not on the punishment of fine or the rest of it. It must be coercive. And, Your Honours, there's reasons for that, and I'll deal with that later if I may. Not just state sovereignty, but issues regarding the protection, not to the witness, but to the administration of justice that flows from a witness giving voluntary evidence. Now, Your Honour, before I move on with your leave, in my submission, even if there was an express provision allowing subpoenas, subpoena ad testificandum, for example, an order, this would not be the case to do it. And why do I say that? There must be a legitimate forensic interest in getting the evidence. Your Honour, it happens in litigation that a party may believe witness A is going to give a certain account. And in good faith, they call that witness. And after taking the oath, the witness turns hostile, displays a hostile animus, or is found not to be desirous of telling the truth. And with the court's leave, the witness may be termed hostile and may be controverted with the previous statement. That is patently not the position that we face. Here, the prosecution are wishing to call a witness to knock the witness down. There is, under the Code of Conduct, an ethical obligation not to present evidence one knows to be false. And here, the witnesses have given accounts in which they say they gave false evidence. The prosecution, we say, are using a procedural device, an ingenious but fundamentally flawed argument, to connive to get a witness before the court.
Mr. Khan, you surely know about the concept of declaring a witness hostile, even your own witness, even compelling your own witness, who was somebody who was on your list but refused to come, to bring them into court and make them a hostile witness and get evidence from them. That's something you're quite familiar with. Why is that so different from what the prosecutor, I don't know, that's what we're going to do, contemplated here?
Your Honour, absolutely an essential provision for administration of justice, the right to declare a witness hostile, for the court to decide a witness has turned hostile, for it to be cross-examined. I have no problems with that. But, Your Honour, when that happens in the witness box,
that's right, but you wouldn't know that until the witness has stepped into the witness box. So we do not know if the prosecutor's strategy here is to bring a witness and tear them apart, or whether once the witness comes in, the witness gives evidence without the need for declaration of hostility.
Well, Your Honour, I think I've read some, and I'll get it later on in the day, if I may. The prosecution have alluded to the possibility that a witness will have to be declared hostile, and indeed that's one of the reasons, it was mentioned by my learned friend this morning, why Article 93(1)(b) would be inappropriate, because of the very great likelihood, the very clear foreseeability that they're going to be controverting their own witness. So, Your Honour, it's a small point, but it's an important point.
Why should that not be allowed? That's a question.
Your Honour, because every party must present evidence that they believe to be true. You can't use a procedural device to call a witness who you know is saying something different, simply to get them before the court, to then controvert them with a previous statement. That's not, in my respectful submission, that is a very different kettle of fish than declaring a witness in good faith, believing a witness will say A, finding a witness says Z, and then seeking to controvert them. So, Your Honour, that's my submission on that particular issue. But, Your Honour...
not on that, moving on. You submit that witness is not compellable. Why is the situation here, why should the situation in this court on that matter be different from, say, the ICTY, where, as you know, in Blaskich, the court went even as far as ordering the state of Croatia to tender documents and officers of that country. Why should that be different?
Your Honour, this court is constrained as an international body created by international treatment agreement by the usual principles of international law. The ICTY, the ICTR, of course, were creations of the Security Council, creating sui generis subsidiary legal bodies imbued with legal powers. Now, Your Honours, those are bodies, those ad hoc courts, clearly had primacy over domestic courts. The word we all know, states shall comply with any order of the courts because they were creatures of the Security Council. This is a completely different animal, this court, and its powers are those that are detailed expressly, we say, or by necessary implication in the statute. Your Honour, there's no power that can coerce a witness. It's not about, the difficulty is not the order that the bench may make. It's what are the consequences and what are the international obligations, both upon the Republic of Kenya and upon the target, which is a witness, to do something which is not expressly required.
But the point is this. If you read the ICTR and ICTR statute, not the rules, but the statute, which in the order of things, we have a statute too. Yes, Rule 54 of the ICTY and ICTR, they do in both places contemplate subpoenas and summonses. And Rule 74 of ICTY rule contemplates contempt of court for failing to appear unjustifiably. But that is, those provisions are in the rules. As you know, the rules, the ICTY and ICTR, are judge-made norms, not Security Council made. The equivalent document would be the statute of those ad hoc tribunals. You compare that to ICC statute, and the provisions on state cooperation more or less say the same things on this. You do not find anywhere in the ICTY, ICTR statute where it is indicated expressly that a court may order a witness to appear before it. But the judges recognize that and put that in the rules. Why shouldn't that happen somehow here?
Your Honour, the basis of Rule 54 and the express provisions regarding subpoena, for example, were drafted by the judges and amended by the judges based upon the statute. And that, of course, has been the case for the last 15 years. Now, Your Honours, the provisions of the statute were clear. The court, the ICTY and the ICTR had primacy. Indeed, the ICTR was created despite the position of Rwanda, which voted in the end against the court, despite initially supporting it because of sentencing and other issues that Your Honour is very familiar with. So it's an assertion, a coercive court from day one, that is imposed on a state despite its will.
The primacy argument, isn't that a question of ranking, if it were? It is a matter of ranking of courts. What has that got to do with the intrinsic power of a court or the inherent ability of a court to be a court where that should be effective in the search for the truth, whether it is the High Court or the Magistrates' Court? If a court that is empowered to investigate, why should it not have the power to be effective?
Yes.
Incidental authority to be effective.
Your Honour, we're very much in favour of this court being effective. That's been our consistent position. But the powers are there. They're the powers in the statute that the court and that the parties, the organs, can actually utilise. They can't conjure up or create inventively or engage in mental or legal gymnastics to contort the express provisions of those drafters of the statute. So, Your Honours, leaving aside the primacy argument, I've made my point for whatever value it's got, is the statute is very clear. about the principle of voluntariness. And it's that the prosecution are seeking to undermine by an argument that we say has absolutely no merit. Now, Your Honour, one issue on the subpoena issue, the argument I was saying about compellability, or the appropriateness to use a subpoena in circumstances where you know the witness is already hostile. Your Honour, in the Kenyatta case, in a decision of in a filing of the 31st of January 2014, the prosecutor conceded at paragraph 8, and I read paragraph 8, nevertheless, the prosecution acknowledges that the hostile stance of these witnesses makes it unlikely that they will provide information useful to the prosecution of the accused. Now, Your Honour, even under the ICTY, one of the important factors in issuing a subpoena is relevance, a legitimate forensic utility, and its material to a live issue. So, Your Honour, according to the stand of the prosecutor in the sister case, the fact of a witness turning hostile shows that the evidential utility is minimal, and that by itself should militate in favour of rejecting the application. Your Honour, the other issues, I don't want to overrun my time. The prosecution conflate certain issues. Effectively what they're seeking to do, because what they're seeking to do is to say there's a difference between appearing before the court, which must be voluntary, and the residual provisions of subparagraph L, which allows the court to do anything. Well, Your Honour, a number of remarks in relation to that. If that was correct as a matter of construction, all the previous subparagraphs would be irrelevant. They'd be OTOs. The drafters could simply have drafted L, that all types of assistance should be given, and leave it at that. Your Honour, subparagraph E is lex specialis. Is lex specialis. It says facilitating the voluntary appearance of persons as witnesses or experts before the court. The drafters could quite easily have left out the word voluntary, because that's what the prosecution basically are reading into subparagraph L. They're saying a court can order a state party to facilitate the appearance of witnesses as witnesses or experts before the court, as long as it's not prohibited by domestic law. So there's many different permutations of drafting that could easily have been done. The reason the draftsman didn't do it is because the Assembly of State Parties were cognizant. I mean, this was an epoch-making court. It is. It is today. And they were trying to balance the competing requirements of efficiency and state sovereignty. And there was a concern both about an overarching so-called rogue prosecutor and a court extending itself beyond the terms of its agreement. And a lot of negotiations went on, not just because of the United States and the concerns of bringing the United States on board, but actually because courts and countries and state parties want to know the responsibilities and the obligations that they're signing up to. Now, Your Honour has touched upon, and it's a key argument which debunks, or some would say puts a blinding spotlight on the issue, on subparagraph 7. It's ludicrous to suggest, we say, that an accused person convicted, a felon in the United States, would have the right to decide whether or not to come before the court, and yet somebody of good character does not. Now, Your Honour, the distinction between the seat of the court and travelling and transport is erroneous. It's erroneous. But for 2 votes in plenary, this court would have been sitting in Kenya. Now, are the prosecution seriously contending, in order to get the result they want, but one that is not supported by the plain reading of the statute, that if Your Honours, if we had the honour of sitting, and the pleasure of sitting in Nairobi, Your Honours couldn't require, because of the provisions of 93(1)(e), a Kenyan national to come before the court. But yet you would have the power to require the same national to go to a building next door and get the evidence by video link. It's nonsensical, we say. It's nonsensical. And, Your Honours, the distinction the prosecution are raising between video link and physical attendance, again, is debunked by their own filing. Because in paragraph 3 of their filing, they concede, whether it's in situ proceedings or whether it's video link, they're trying to get the witness to appear before the court. The exact same language of article that is prohibited under Article 93(1)(e) unless it's voluntary. So it makes no difference. If a witness is from Timbuktu and appears by video link, that witness is appearing before the court. Mr. Ruto is not physically present before this court, but he is present in this courtroom. He's represented by counsel. So the argument put forward by the prosecution falls on many different counts.
Why do you say that? Why do you say that the distinction they try to make in relation to 93(7) is nonsensical? Isn't the argument this, as Mr. Stewart had said, that you have somebody who's in custody as a result of the processes of the forum state? The person is serving sentence, term of years, and there is some humanitarian sensibilities to compounding that state of disability by also moving that person in the condition of disability in custody and moving the person into the custody of another place or another court. I mean, the distinction might be highly evolved, but it isn't that evanescent, is it?
Your Honour, in my respectful submission, that argument is wholly without merit, because the Secretary General's reports dealing with the ICTY and ICTR made it clear that the court was seeking to apply the best international human rights standards to the court. Now, we have, over the last 15 years, goodness knows how many convicted persons from the ICTR and from the ICTY. And is there a presumption that they serve their sentence back in the country, even those countries now that are part or seeking to become part of the European Union? No, they find themselves in Italy, in Sweden, in the Netherlands, in the United Kingdom. And so that humanitarian principle, if a principle it be, must be applied consistently. It cannot be extracted from a general principle of law recognized by countries, we say.
Yes, but the difference there is, I mean, that's where the distinction with Rule 193 comes in. And Mr. Stewart also submitted to that. The difference is, in Rule 193, you're dealing with your own prisoner. So if you send them somewhere, you can also move them back. They are where they are as a result of the due process of your own court. And that's not the same thing with the sort of person we are talking about implicated in Article 93(7). They are serving sentence as a result of the due process of one court. They're not there as a result of the due process of some other court. So there is something quite not right about shifting them from where they are, from here to there.
Your Honour, if it was permanent transfer, in my respectful submission, my learned friend's argument may be a little bit different, a little bit stronger. But if it was simply focused solely on issues of state sovereignty, there would be no requirement for the consent of the prisoner, for the detained person, because an individual has no say if he is kept in Arnhem prison or in Scheveningen prison or in Amsterdam prison. It's a matter for the state. His liberty is restricted. So if that was, one is looking at it from a human rights-centric point of view, and it doesn't come within that category in my respectful submission, the state sovereignty aspect could be properly met by the second limb, that a state will decide if somebody in custody could come to the court, if so, for how long, and, of course, the provision says must be returned as soon as possible thereafter. But, Your Honour, it doesn't say that. It says very importantly and critically, the person who's a convicted criminal or a person who's otherwise in detention must have a say and must consent. Now, Your Honours, what are the prosecution saying? One of the principles of law, it said, is deterrence, and there's a whole amount of argument on whether or not that's effective and all the rest of it. But here we have witnesses who say, who've been convicted, they've been incarcerated, they're on travel bans, they can't enter this country. Some are alcoholics, some are, have psychological problems. The prosecution glossed that away and said the only reason why they're not coming is a sniff of foul play. We say that's a smokescreen to put a defence in advance for the day we say, with the greatest of humility, this case collapses. They're trying to say and change the narrative it's because of Kenyan non-cooperation, not because they got the wrong people to start with. It's a fundamental point. It's a fundamental point. But Your Honour, are the prosecution, well, the prosecution, I say, cannot, would not, incite crime. Because these individuals, wherever they be, if they do not want to come voluntarily, are they saying, well, get yourself locked up?
3 more minutes.
Get yourself locked up, commit a crime, commit a burglary, and you'll get outside the long arm of the prosecution or the long arm of the court. Because once they're in custody, the prosecution concede that subparagraph 7 would act as an absolute bar to compelling them to testify. So, Your Honours, we get in knots, we get into numerous difficulties, and the reason we do that is we're seeking to force, a round peg through a square hole. We're trying to twist, painfully contort, a clear statutory regime to one of convenience that the law does not support. Your Honour, I'm handed by my learned friend Miss Laurie and Miss Alexandra an article from Mr. Raston, and it's at page 442 of his article, and I'll just read the highlighted bit. And he states that, furthermore, the principle of attribution holds that an international organisation cannot act beyond the powers attributed to it by its constituent treaty. And, Your Honour, that, of course, is the point I was raising earlier, that we're bound by the statute. And I think
it goes without saying, of course. We all agree with that. We all agree with
indeed.
that, yes.
So, Your Honour, the point is, sometimes the simplest solution is the right one. Here we have a regime of cooperation. The prosecution have not acted and done the right thing at the right time. We've seen that with disclosure, judicial comment, and criticism has been made of that. We've seen that on numerous issues, and we see it in relation to 93(1)(b). They didn't utilise a power that was there, that would have solved this problem. Instead of seeking to adjourn the case, they marched on, thinking that they'd be given a blank cheque and they get the result that they wanted. And, Your Honour, it's the same problem, whether it's legal recharacterisation, whether it's temporal scope of the indictment, or whether it's 93(1)(b), taking testimony under oath. The prosecution haven't used the powers that are there, and that should not grant them the benefit of conferring on them a power that the statute does not give. We say the application is inherently implausible, without legal basis, is contrary to the intention of the drafters, and should be rejected. I'm grateful, Your Honour.
Thank you very much. Mr. Kinkatwa?
With your permission, Mr. President and Your Honours, I propose to have Ms. Caroline Buisman to address the court initially.
Mr. Buisman will be rising in 15 minutes for morning break.
Good morning, Mr. President. Good morning, Your Honours, everyone else. Well, we basically made 4 critical points, and the first one is that the statute does not allow the court to compel witnesses to testify. And the second is that the court doesn't have the power to impose a duty on any state to compel witnesses to testify before the ICC. And we also said that in any event, the Kenyan law doesn't allow it, and also that in this particular situation, the prosecution has not made a case to actually justify such a request. I'll be very brief, 15 minutes.
If I can help you, I'm interested right away in the proposition that the statute, did you say, does not allow? You actually use the words, does not allow compellability. Isn't that something that needs to be quite explicit in the statute?
Mr. President, we think it is quite explicit if we read 93(1)(e), because it does actually refer to voluntary appearance, and it doesn't actually make any distinction between transfer and non-transfer, because this seems to be the main argument, that we can somehow make a distinction between those who actually testify in the States or those who testify before the ICC. We say on the basis of 93(1)(e), which is very clear that it only allows voluntary, it only requires states to facilitate voluntary appearance.
But that's something different, requiring a state to facilitate it. Let's accept the proposition that at the end of the day, after construing Article 93, it is agreed, for argument's sake, it is agreed that Article 93 says voluntary. There's no compellability there. Should we take that outside of the context of Article 93, which deals with a request that may be made of a state party? In other words, you may have a situation where, let's assume that we agree, 93 says only voluntary and not compellability. Is there more to it than this? State party A, we want you to compel a witness to appear. State party A says, well, we've looked at 93, we all see that it's voluntary and not compellability, but it's about an assistance that we can give. We agree to compel the witness. Is that prohibited by 93?
Well, we say yes, because we say if you look at Article 64(6)(b), that makes the explicit link to state cooperation. And unlike the ICTY and ICTR statutes that are not drafted by states, and the states have not signed and agreed that statute was imposed on states, and that is a big difference. Here we have a state that has chosen specific words, and that was chosen by states. We cannot now rewrite that statute unless we have another provision amended by the Assembly of States. And if you look at the statute in totality, we suggest that there is actually, we cannot compel witnesses to testify before the court, irrespective of what the law of the state says. And I'm relying on Article 64(6)(b), read together with 93(1)(e). Then there's, of course, what you already mentioned, the 93(7) provision, which says that persons in custody must give their consent. And you already mentioned it, Mr. President, that it is rather an absurd suggestion, although that was not exactly what you said, but that's my submission, that if someone who's already in a compelled situation, if someone in that situation actually has to give consent, but someone else who is not in a compelled situation yet, we can allow a state to put that individual in a compelled situation. And we are not yet discussing, are we only talking about fines, or are we also talking about imprisonment? Because the moment an individual is imprisoned, then there is no reason why that individual would be in a different position than an individual already in custody. And the individual already in custody under 93(7) is actually explicitly required to give consent. So on that basis, we say it's very natural to draw the same conclusion for someone who's subject to a summons order from this court. And unlike the ICTY and the ICTR statutes, they did not have these explicit provisions. There's no provision in the ICTY statute similar to 93(1)(e). There's nothing that sort of requires the voluntary appearance or the consent of anyone, whether in custody or not. So there are differences. So we do say that on that basis, the court cannot infer a power to summon witnesses against their will, because the consequences are actually rather intense.
What does require mean in 64(6)(b)? 64(6)(b) says, you have it. In performing its functions prior to trial or during the course of a trial, the trial chamber may, as necessary, require the attendance and testimony of witnesses. We can stop it there. We know it also further down. It says, if necessary, by obtaining the assistance of state. But leaving it there, require the attendance of testimony. I say this because you say the statute does not allow witnesses to be compelled to appear. But we have this provision that says that the court, if necessary, may require the attendance of a witness. Now, Mr. Stewart has submitted that in the French text, the word ordonné is actually used, and we know those who speak French, ordonné, what it means. How do we say that the statute does not allow a witness to be compelled as a matter separate from requiring a state party to be complicit in that kind of activity of compelling a witness to appear?
Mr. President, I submit that Article 64(6)(b), indeed, in the French it says ordonné, but in English it says require, and it's actually the only English provision where they use the word ordonné, where they use the word require. So we say that was actually a deliberate choice of words. And when you look at, for us, there's no inconsistency.
Are you saying that require in the English language may not mean order or compel?
Indeed, Your Honor. I think it's a less extreme, it's a less forceful term, and I think there was a reason why they used the word require rather than order. Order is very explicit. Require is not very explicit. And
Ms.
Mr.
Postman, I
President,
brought the thesaurus in the courtroom, you know. If we can turn to, I will turn to it.
but if, okay.
So you can trust me. I know you don't have the text in front of you. I'm looking at the Oxford Thesaurus. Under the entry require, 1, order, command. Those are the first two entries. Ask for, call for, press, instruct, coerce, force, insist, demand, make, and so on. And you're saying that require excludes all that. Is that your submission?
Mr. President, it's admittedly not one that I looked at. There was another dictionary that I've looked at and that did not actually define require. But I still maintain that there is it's a more forceful term, and you use the word order, then it's more explicit. It's clear what we mean. When you say, I can order you, we know that it means that I can give you this instruction and you have to comply by it. Whereas require, I think in the context of Article 64(6)(b), is more about arrangement of the facilities. And I also think the more important argument is that Article 64(6)(b) is not linked or coupled to any power to impose sanctions on anyone who doesn't actually comply. So the way I read Article 64(6)(b) is that this provision allows the court, the chamber, to require the parties to call additional evidence, because we obviously provide the evidence, and at the end of the day, you may feel the need to hear more, and that's at that moment you can require the attendance of a particular witness not yet heard, like in the case of Bemba, they called a witness of the court. But that doesn't mean necessarily that then, if the particular witness in question is not willing to testify, that you can compel this witness to testify. In our submission, that is a whole different power that is not included in Article 64(6)(b). And rather, we say that that particular power is excluded by Article 93(1)(e) and 93(7). That is our submission.
Thank you very much.
Could I just...
Go on. I take it Ms. Bergman had 3 or 4 minutes left, so we'll take it. She's yielding those to you.
Well, Your Honor, I can raise it later, perhaps.
Maybe 2-2. Just very briefly, because it's actually already been said. I just, on the issue of 93(1)(l), we submit it's not an open-ended submission. You cannot use 93(1)(l) to circumvent a very explicit provision excluding such compellability. That's our submission. On the Kenyan law, I will leave it to our Kenyan colleagues in court. And on the issue of this particular case, we submit that guidelines need to be adopted when if there is going to be a power to compel witnesses, then there must be certain guidelines to be respected. And we have suggested, obviously that is something for you to determine, to look at the ICTR in this respect. And we set out 3 criteria that it must be shown that it's necessary, that the compelled testimony materially assists the court, and that it's not obtainable through other means. And we say that in this particular case, given the complete lack of credibility of these witnesses, such a request was not made out. And I'll give my last 2 minutes to my colleague. Thank you.
While you're on your feet, and Mr. Khan, when you stand up to speak, you might also address this. This is a peculiar question for defense counsel. So here we are. You tell us the court does not have the power to compel. Now, sooner or later in this court, it's a matter of time before this scenario arises. You have a case where perhaps the case for the prosecution is built on circumstantial evidence that put together may tend to show proof of guilt, but the defense says, judges, there is one exculpatory witness somewhere who, when he or she appears, will make it very clear that my client did not commit this crime. The problem we have is that this person does not want to show up, does not want to come to court. Maybe because their employers don't want them to come to court and testify. And are you telling us that this court will have no power to compel the attendance of such a witness, both of you?
Well, unfortunately, I do. I do see the problem, and it was already pointed out by my learned friend on the other side. I just want to highlight, this is a very strong argument of Sluiter, who is the leading academic in arguing that there is no right for the court to compel witnesses against their will. And yet, he sees it as a real weakness of this court. Yet, that's not a reason to rewrite the statute. That is a reason, perhaps, to look at the statute again and ask the Assembly of States to amend it.
And you're saying, despite what require means, there's still need for amendment. Anyway, Mr. Khan, can you advise us what you imagine the scenario I've indicated? Are we then to set a precedent that says, no, yes, such a witness exists that may come and testify and give exculpatory evidence for the defense, but the court has no power to compel that? What justice is in there? Tell me.
Your Honour, one thing is, as the Americans would say, what's sauce for the goose is sauce for the gander. There must be a reciprocity for fairness regarding application of rules, and the right of the defence is calling witness under the same terms as the prosecution. Now, of course, the prosecution have the burden of proof, and if there were circumstances where the defence could not get a witness, and evidence in some other way was presented that shows, for example, that due to non-compliance by a country, the defence had been materially prejudiced, having professional judges hopefully would allow the court to assess the evidence fairly. I mean, that's precisely the situation in dealing with the Darfur rebel case, where defence cannot go in, cannot subpoena witnesses out, and in those circumstances, the bench has very properly said, being professional judges, they will be able to assess that at the end of the day. So, Your Honours, we could not create or carve out for ourselves a power to compel against a witness's will in circumstances where we say that the prosecution, and well, rather the statute, denies that for both parties. These provisions are drafted applying to the parties as a whole, and one of the essential requirements is it's voluntary. Your Honour, the other point I wanted to raise deals with the issue of Article 64. In my submission, an interesting academic...
Mr. Khan, we're already past 11.
I'm grateful. I'll deal with it later with your leave, Your Honour.
All right.
I'm grateful.
Court will now rise and we come back at 11:30.
All rise.